we'll call our next case. I'm not going to pronounce that last name. Torrado versus Hilton Miami Airport Hotel.
May it please the Court, I'm Kimberly Hill on behalf of Edilia Torrado. This is an appeal that arises out of the employer carriers 440-105 and 440-09 so-called fraud defense case upon which a JCC ruled against the claimant as to the June 11th, 07 date of accident. There were actually two accidents in this case, and they were consolidated cases. In one of the accidents, the judge of compensation claims determined that the claimant did not violate the provisions of 440-105 and 440-09, and in the other case, the 6/11/07 date of accident, the judge of compensation claims found that she did violate the provisions of 440-105 and obviously forfeited benefits based on 440-09. It seems...
Isn't this really a CSE question? And the JCC heard the client's testimony. She had denied having had any problems with her right shoulder. That obviously was not true. Now, you have stated that she was not too proficient in English and different things, but isn't that something that we can't really base an appeal on? And the JCC had considered that, and you lost, and under our rules, we're sorry, but that's the way it is.
That's okay. I will address that. And actually, that was going to be my first point, and that is, assuming I can't get past that particular issue of the actual statements themselves, obviously based on the CSE standard, there's still a question, and again, you know, I admitted, obviously, in the initial brief that the claimant, in her deposition, in fact, did deny that she had a prior right shoulder problem, that she had any prior problems, which is how it was stated in the deposition. And although I might not agree that it was necessarily, you know, it's somewhat vague of a question, there was no objection or anything of that nature as to the vagueness, and that is the judge of compensation claims within his domain to determine, obviously, whether or not someone made a false or misleading statement. However, in this case, it's more the second half of that standard that my argument is focused on, and that is that there's no competent substantial evidence in the case that the statements were made for the purposes of obtaining benefits. And really that's where I would really like to focus, because obviously she made the statements, there's no question about that, and no, you cannot reweigh the evidence, and I understand that the judge of compensation claims made that finding. However...
Why else would she make the statements if it wasn't to obtain benefits?
Well, let me explain. Let me take a step back and basically give a timeline that may help clarify and explain why. I don't know why she would have made the statements, to tell you the truth, but basically what had occurred in this situation are, obviously there were two dates of accident. There was a stipulation, and we're just dealing with the second date of accident. I waived any arguments in relation to any benefits that were denied in relation to the first date of accident. What occurred was on December 23rd, 07, the parties came together and entered into a stipulation resolving all past benefits. That means all temporary benefits that were due, all medical benefits that were due. The only thing that was left open were the issues of attorney's fees and costs between the claimant's attorney and the defense attorney. And that was on December 23rd of 07. Well, I'm sorry, the benefits were resolved through December 23rd of 07. The stipulation is in the record. The claimant's deposition, for some reason, was taken very shortly after that, on January 2nd of 08. And at that point in time, there were no petitions for benefits pending at all. So the question in my mind is, first of all, if there were no petitions for benefits pending at that particular time, I raised a jurisdictional argument, too, which is semi-related to the argument that I'm discussing here, and that is that the claimant's claim was not for the claimant's statements were not made for the purposes of securing workers' comp benefits because there was no petition pending at the time the deposition was given. So how could they possibly pertain to a petition for workers' comp benefits? And the way the statute reads, which is 440-105 and 440-09 both, use the specific language for the purpose of securing workers' compensation benefits. And the only way to secure workers' compensation benefits in this system is to file a petition for benefits.
Well, let me just quote some language to you from the Village Apartments versus Hernandez case. I mean, you can nitpick all day long about the day she said it and why she said it and the other day that she said it. But the settled principle is, and I quote, "The parties have a right to expect that all statements, whether written or oral, are truthful, responsive, and complete." And isn't that really what we're dealing with here?
Well, I agree. I agree with that statement. That's when the cases are in actual litigation. I don't know why the deposition was taken then. I don't know whether it was a deposition that had been set previously when an original petition was filed, but the fact remains that all of the petitions were resolved. So this is supposed to be a self-executing system. At this point in time, there were no petitions pending. And I think that is particularly relevant. There are several cases, and while they may not apply directly unless you want to really apply them to the jurisdictional argument that I made, which is the third argument in my brief, and it really, I think it's 2 or 3 cases that are applicable. In those particular cases, what had occurred was the claimant, and this is distinguishable because there were no dismissal of petitions in this case, and I admit that there actually was a pretrial entered maybe about 3 or 4 months after this deposition was given. So maybe from that point forward, the judge had jurisdiction, and I think that might even be questionable, and argue that it was, because a petition is what gives the judge jurisdiction to begin with to move forward on a claim. And for some reason...
So if the untruth happened before the judge has jurisdiction, he can't rule that it was untrue? Is that what you're saying?
Well, he can consider it, but he still has to find that there was intent at the time. And if there was no petition pending relating to any benefits that someone was trying to secure, then where's the intent in the mind of the claimant? There can be no intent if there's no petition pending at that time. Who knows why she said those said she didn't know, but then in the subsequent deposition...
So an employee in a convenience store shoots himself with his own gun, okay? And he's...
I'm sorry, let's start over.
He tells his employer that he was robbed and he was shot. And they start providing benefits. And at some time they decide to stop providing benefits, and he files a petition for benefits. So that untruth is not in seeking workers' compensation when he lied because there was no petition filed yet?
Well, that seems to be what the statute says. I mean, and it says for the purpose of securing workers' comp benefits. We all know that...
Let me ask you right there, Ms. Hill, this deposition is where she made these statements.
Excuse me?
She made these statements in deposition.
Yes, she did.
All right. When I take a deposition, there usually be the style of the case on the face of it. These depositions where she made these statements, what was the style of the case? And I really don't know. It just occurred to me that if this wasn't in the workers' comp context, then the style of the case should be in a civil action. Can you give me what the face of that
well, the style of
deposition
the case,
is? Would you read that for me, please?
Sure, yeah. The style of the case was Edilia, Torrado versus Hilton Miami Airport Hotel.
And
So
what is it? It's in what agency? Division of...
Oh, well, yeah, it would have been the Division of Administrative Hearings. I mean, I'm looking at the record.
So she was making those statements in a deposition that everybody there knew was for a workers' compensation claim because the style of the case is even that way, isn't it?
But no, because it's not a claim unless you're seeking benefits. I mean, even in these other cases in which the question is intent. I mean, it's not a question.
Let me stop you right there. You don't take depositions unless you're seeking something in the way of money damages in our context usually, or something like that in this area, right? You don't go out and take depositions unless you want something.
That question might be better posed to Mr. Barnes. He was involved in the case below, and he actually, he actually took the deposition of the claimant. But at this particular, there are many workers' comp cases that are pending where there are no petitions, and I did it from both.
They're taking depositions every day, getting ready to file a petition.
Who knows if it? The claimant was set for deposition. I don't know why she was set for deposition. All the issues had been resolved at that particular point in time. I'm sure that probably what happened, and you know, this is really more of a guess on my part. For all I know, there was a deposition prior to this. I don't know, but. You know, just having been engaged in workers' compensation litigation for a long period of time as a defense attorney for 17 years or somewhere along those lines, a lot of times it's very difficult to get these depositions in early. So it may have just been a deposition that was set in the course of proceedings, and then the claimant, and then the parties went to a mediation, resolved the issues that were pending, and then the claimant then they proceeded with the claimant's.
It wasn't just a casual conversation. It was a statement under oath for purposes of obtaining benefits.
Well, I don't think it was for the purposes of obtaining benefits, because what benefits was it to obtain? There was no petition pending at the time. Everything had already been paid at that particular point in time. So the claimant had no pending petitions, and the subsequent petitions that were actually filed in this case related to medical benefits, and that's, I mean, maybe the point that I'm not getting across is that there actually, aside from the fact that there has to be a misstatement, it also has to be made with a specific intent to advance a claim. And that's what all the case law says that has come out of this court. And you know, so if there's no claim, then how can the statement that was made in that deposition be made to advance the claim? You know, just because you have an ongoing situation, unless there's actually a petition pending, someone can, I find it very hard to see the argument that a statement was made to advance a claim. I mean, a lot of statements are made. Subsequently, the claimant was deposed again, and at that particular deposition, she said she didn't remember whether she told a doctor something or one thing or another thing. And
one more question. I said to myself I wasn't going to ask another. Were the depositions we're talking about introduced in evidence at a hearing on workers' compensation claim of your client?
Yes, but that was after. Subsequently, additional petitions were filed, which invoked the jurisdiction of the judge of compensation claims and resulted ultimately in a pretrial, and the parties proceeded to hearing. So at that point, yes. And the other point I would like to make in terms of the petitions that were filed, there were two other, I think it was three other petitions actually filed after this deposition was taken. And part of my argument, it was really the third argument, was the jurisdictional aspect of the case, and that is one of the petitions was for medical bills, which, and this obviously has been established in this court that a judge of compensation claims doesn't have jurisdiction of that, and that is part of the argument. I mean, there's similar arguments as far as jurisdiction and whether or not there was any intent, and that is if there are no petitions pending, the judge of compensation claims has no jurisdiction to rule on anything. And I think that was a point that I was trying to make earlier, and that is there are several cases, 2 or 3 cases in this court wherein the claimant withdrew petitions and the judge proceeded to rule on a fraud claim in any case, and this court reversed, basically saying that if the judge doesn't have jurisdiction over the issue, then he can't make a fraud ruling, in essence. And that was part of my argument as well, because there was never a petition pending in this case over which the judge had jurisdiction, even when it went to final hearing. There was a claim for medical bills over which this court has indicated the judge doesn't have jurisdiction. ACCA has exclusive jurisdiction over that. There was another claim for 4 weeks of permanent, not permanent shuttle, physical therapy, and the carrier resolved that issue prior to going to hearing by giving the claimant the physical therapy. And the other issue was a change in authorized doctors, which is also given to the claimant, so there was no issue. The only possible issue was TT and TP, and there was never a petition filed for that, which I explained, and I don't know why there wasn't a petition, but then it was raised on the pretrial, and I guess arguably you could say that the judge had jurisdiction once it was raised on the pretrial to adjudicate that. But once again, that was 3 or 4 months after these statements in the deposition were made. So if there are no further questions? No.
You got 20 seconds for rebuttal.
Oh, no. Thank you.
Good afternoon. May it please the Court, my name is Doug Barnes. I represent the appellees in this matter. And this case clearly is one of simply competent, substantial evidence, as the Court questioned Ms. Hill about earlier. I believe that's what it is. There is competent, substantial evidence in the record, and it should be affirmed. Let me get to the issues that your honors were raising about the jurisdictional issue. The point was raised by myself to the judge at the trial level in regards to the TT and the TP issue. That being that I made the argument that since there had not been a new petition filed after the mediation agreement, that there was no claim pending, and the judge specifically rejected that argument. As the Court will see from the claims listed by counsel for the claimant, she listed temporary total / temporary partial disability claims after that mediation agreement. The judge accepted her argument at trial that the petition for benefits, and I'll read it to the Court, which was dated 10/2/07, and this is what brought us to the mediation in December of 2007 when we reached the mediation agreement. It was for temporary total at the correct compensation rate, or alternatively, temporary partial at the correct compensation rate. And on the petition, the boxes are checked off for continuing. In other words, these were continuing claims. We had resolved the indemnity benefits up until the time of that mediation agreement. The judge found, I disagreed, but he found that it was a continuing claim based on that petition, that he had jurisdiction. And counsel for claimant argued against my motion, of course, because I actually filed a motion to strike the claims in the pretrial because I felt they had been resolved via the mediation agreement. The judge ruled against me on the motion, overruled my objection. And I can give you the page. It's in page 54, I believe, of the record at the trial, where I actually raised that issue again, and the judge overruled my objection, and we proceeded to trial on the claims for temporary total and temporary partial disability benefits. As such, the judge clearly had jurisdiction based on his rulings for those claims. And based upon claimant's counsel's argument to the judge, she was pursuing claims for those benefits. And as such, the Court had jurisdiction to rule on those claims and to rule on the defense that we raised, which was that she had made false, misleading, and or incomplete statements in order to secure workers' compensation benefits. As the Court pointed out earlier, it was a deposition. I, as the trial counsel, always start out my depositions with warnings. I advise them. Do you understand that you've taken an oath to tell the truth today? Yes. Do you understand that if you don't tell the truth that you can be prosecuted for perjury? Yes. Do you also understand that if you don't tell the truth, the judge of compensation claims could deny your workers' compensation claim? Yes. She answered those questions affirmatively with the aid of an interpreter. So the reference in the arguments about she was uneducated and only spoke Spanish, she had an 8th grade education. She could read and write in Spanish. So she was not an illiterate. She just didn't understand English very well. We had a Spanish-speaking interpreter for both depositions as well as the court proceedings before the JCC. Interestingly, the JCC also admonished her at the time of trial about telling the truth, understanding the significance of taking an oath. And she again acknowledged the significance. And if the court looks at the testimony from her deposition to what she testified to at trial, I think that also goes to intent. Because in deposition, when I asked her these questions, I asked her specifically, have you ever had any injuries or problems with your right shoulder before your accident with Hilton?
Was there an objection to that question?
No, there was not, ma'am. The answer was an emphatic no. No qualification. No, I don't remember. No, I'm not sure. No. Did you ever receive any medical treatment for any problems with your right shoulder before your injury with Hilton? No.
Again, no objection.
No objection. The only point that counsel raised on appeal was the injury or problem and maybe some confusion about problem. The other questions are far more direct, and they're not ambiguous in any way. Have you ever received medical treatment for your right shoulder before the accident with Hilton? No. Well, now, people remember whether they've had medical treatment for, most times, different body parts. That's something that is, I think, fairly simple. I also asked the direct question, have you ever treated with Dr. Matrani, the primary care physician's records that we relied upon to a large extent in establishing that she had these complaints? And the timetable is also significant, as counsel was pointing out, because she was complaining about these problems with the shoulders, both shoulders, in February of 2007 and May of 2007, which was a month before her accident. So this wasn't something that was distant. This was very recent in the time frame as far as her accident. She should have remembered. I believe the judge made that conclusion. He weighed the evidence. He is the one who has to make that determination as to credibility, and I think he made the correct determination, and I would ask that the court affirm the decision. Thank you.
Here, you got 20 seconds, but I don't think anybody would protest that we took a minute to wrap it up.
I don't even know that I'll need that much. I really just wanted to reiterate the point that I think is important. Understood that obviously competent substantial evidence governs the question of whether or not this statement was made, obviously, or a misstatement, a fraudulent statement. The question really is, it's always a two-part inquiry, and I think that the point in this case that the court should really focus on is, if there is no claim or PFB, how can there be an intent to advance a claim? Because these items are supposed to be self-executing claims. I understand that the claimant said in her deposition that she did not. I can't explain why she did or didn't admit to having prior shoulder problems, whether she understood or didn't understand, and it really, in the end, doesn't matter, because once the finding is made that she made a misstatement, then we're pretty much stuck with that finding. But so I think that the real question here is whether or not there was intent, and that should be the focus of the court. Thank you.
Okay, well, that concludes our docket today. This proceeding is adjourned, and the court will be